Good morning and welcome to the American Health Lawyers Association's Antitrust Practice Group program on the recent St. Luke Hospital versus ProMedica health system decision out of the Sixth Circuit. Recently, as many of you healthcare antitrust practitioners and watchers must know, the Sixth Circuit panel vacated a preliminary injunction enjoining a health system from removing a competing health system from its integrated insurance company's network. Today's program is designed to give some brief background on this case in terms of facts, arguments, and defenses, and also some takeaways for healthcare providers and managed care systems, as well as their counsel. We have a special treat today. We're joined by two healthcare antitrust specialists. First, Doug Litvack, who is a partner just recently at Jenner & Block, who specializes in antitrust counseling and litigation with a particular focus on healthcare and consumer products. And as a special treat, he was also counsel to ProMedica in this case. Before entering private practice, he was a trial attorney at the FTC, analyzing challenging mergers, including participating in noteworthy enforcement actions in the healthcare sector. We're also joined by Barbara Sicalides. And excuse me, Barbara, if I mispronounced that, I butchered your name. But Barbara is a partner at Troutman Pepper, and she counsels clients on antitrust and competition issues, as well as representing clients in civil and criminal antitrust litigation, and also does a great deal of antitrust work in the healthcare sector. And lastly, your moderator, I won't have that much to contribute to this conversation, but I'm a member of the Antitrust Practice Group of American Health Lawyers Health Law Association, and I am a counsel at Shook Hardy in Bacon in San Francisco, where I specialize in business litigation for focus on antitrust consumer protection issues. And without further ado, I'll start the conversation by first turning it over to Doug, who will give us a brief recap on the case, the facts of the specific case in front of the circuit court, as well as a brief discussion on the background of the case, including the FTC investigation and enforcement action that kind of led to this in a roundabout way. Doug?
Thanks, Steve. So the story begins in 2010 when ProMedica acquires St. Luke's. It then goes through a long battle with the FTC, ultimately ending up divesting St. Luke's per an FTC order. And as part of that divestiture, ProMedica had to lend temporary and extraordinary support to St. Luke's to get it back on its feet as an independent hospital. And part of that support was giving it in-network contracting status to its insurance company, Paramount. And it had to do that for at least 3 years. However, there was a provision that said that if St. Luke's underwent a change in control, that ProMedica no longer had to keep St. Luke's in its insurance network. And so that then in 2018, 1 year before that contract expired, ProMedica and St. Luke's engaged in a discussion over ProMedica having a cancer center on St. Luke's campus. And in exchange, ProMedica agreed to extend the Paramount insurance contract relationship with St. Luke's until 2023 to align with the cancer center relationship. However, ProMedica negotiated and St. Luke's agreed that the change in control provision would still apply that was in the FTC divestiture agreement. And then in 2020, McLaren Health System, a large vertically integrated system based in Michigan, acquired St. Luke's, triggering the change in control provision, which then ProMedica responded by sending out termination notices to St. Luke's saying that it would no longer be in its insurance network. And then what ended up happening is that McLaren St. Luke's sued, claiming an antitrust violation for allegedly terminating the insurance contracts with Paramount. And what ended up happening is the district court agreed and preliminarily enjoined the contract, saying that ProMedica had a duty to deal with McLaren St. Luke's, despite the change in control provision. And we ultimately, for ProMedica, appealed that decision and were successful in the Sixth Circuit, persuading the Sixth Circuit that there was no duty to deal under the antitrust laws. And so that's the quick version of the facts in this case. And I'll turn it over to Barbara to explain the theory of harm.
All right. Well, first, congratulations, Doug, on the win, though I know the case isn't over yet. So
Not over.
I don't want you to count your chickens before they hatch, but nicely done. So the theory of harm in the case is not, as I wasn't a party of the case, right? So based on the materials that I've read, the theory of harm is not entirely clear, but what the plaintiff seems to be focused on is that they are the best alternative, the closest alternative to the plaintiff's healthcare provider in that region, and that to the defendant, sorry, to ProMedica, and that ProMedica has allegedly taken certain steps that have pushed the plaintiff to sort of the edge of its competitiveness and its ability to be competitively relevant in the geography. They also focus on the fact that, according to the complaint, ProMedica is high cost and doesn't have particularly high quality ratings, while their system, St. Luke's, is purportedly the lower cost provider, and that they at St. Luke's has high quality metrics. So it paints the picture, right, that St. Luke's is on the edge of competitive relevance, which, as I said, the complaint suggests is in part, at least in part, the fault of actions taken by ProMedica, allegedly anti-competitive actions, including payer agreements that excluded St. Luke's, and this is before the termination, gutting St. Luke's during the merged period, and barring some physicians from practicing at St. Luke's. These are allegations. Whether they're true or not, I can't speak to. And also imposing debt on St. Luke's that, as a result of the merger being unwound, was burdensome. And that there was going to be a loss of access to volume with the termination by Paramount. And that loss of access sort of put St. Luke's over the edge of being able to be an effective competitive restraint on Paramount. I'm sorry, not on Paramount, on ProMedica. So I'm using more words to describe this than, although not as with the same amount of specific detail as the complaint. And so maybe I'm filling things in or reading between the lines in a way that, Doug will tell me is either wrong or that he disagrees with, one or the other. But in my view, that is what the focus of the plaintiff's harm theory is, which is currently we are competitively relevant, but we are hanging on by our thumbs or fingertips, and that this loss of access to the Paramount volume will put us closer to, or maybe over the edge of being competitively relevant. And that in addition to that, the loss of any market share by St. Luke's will cause harm to the public, to the consumers, because, and they rely on studies in their complaint for the evidence for this, which is that with any increased market concentration comes necessarily higher rates. And therefore, even if St. Luke's, or I should say, even if ProMedica only gains a share or 2 or 3 from St. Luke's loss of access to Paramount, that will result in some measurable harm to the consumers through higher rates and the loss of access to the patients specifically, members specifically, who will be forced to use, in their argument, forced to use ProMedica instead of having the ability to turn to St. Luke's. So that's my understanding of the theory of harm. I'd be interested in hearing Doug's response to the theory of harm and the defenses that they launched in the case.
I mean, Barbara, you did a good job because the complaint is long, confusing, and has lots of various allegations that don't seem to tie into any specific theory of harm. And what the plaintiff, in my view, is trying to do is say, this is a monopolization case. This is a case where ProMedica allegedly is a monopolist and they see a threat of a new competitor emerging, and they're engaging in various conduct to eliminate that threat. And that'll actually feed into what I think the key defense is for ProMedica and was our key message throughout the case, which is this is simply competition on the merits. And consumers benefit when firms compete. And that's all that ProMedica is doing here, is engaging in vigorous competition with a new, strong competitor with deep pockets. And that will benefit consumers. And in fact, what the court did by enjoining a part of that competition, the court essentially stopped healthy competition that will benefit consumers. And that's like thematically what the defense that ProMedica brought in the district court and then persuaded the Sixth Circuit was correct. And the case in front of the Sixth Circuit focused and centered in on whether it was unlawful for ProMedica to terminate the Paramount contracts. And that claim falls into the category of what we call as antitrust lawyers, like duty to deal or refusal to deal claims. And the antitrust laws generally impose no duty to deal with a competitor, absent extraordinary circumstances that are found in the Aspen skiing case. And there's a very narrow test to show those extraordinary circumstances. And ProMedica's defense was all along that the plaintiffs didn't satisfy any element, let alone all the elements, to meet that defense. And particularly, ProMedica argued, and the Sixth Circuit agreed, that there was no prior voluntary course of dealing with the plaintiffs because ProMedica never agreed to deal with St. Luke's if it underwent a change of control, and never agreed to deal with McLaren St. Luke's, which is a decidedly different competitor by the plaintiff's own complaint. And that fact alone, we felt, and the Sixth Circuit agreed, was dispositive in rejecting their claim that this could be an antitrust violation. And to add, there needs to also be a profit sacrifice, meaning ProMedica needs to be engaging in behavior that makes no business sense but for its anti-competitive motive. And we put forth a ton of evidence suggesting that this was profit maximizing behavior, competition on the merits, because ProMedica is a provider, first and foremost, of healthcare services, and uses its insurance arm to really drive volume to ProMedica providers. So it's completely profitable to terminate a relationship with a different provider who could siphon off patients from ProMedica facilities to their facilities, destroying the value of having the vertically integrated health plan as part of its provider system.
Did you think?
Yeah, what?
Did you think that the district court judge believed the second prong of the test in Aspenski was met by the fact that, well, if it wasn't a profitable relationship, they wouldn't have had it to begin with. And that struck me as a bit of a problem, because if that alone is enough evidence, then you basically turn the narrow Aspen skiing into a big, wide open gate. But that was how I understood the case was presented. And I'd be curious if that's true and how it was that the court, Sixth Circuit and District Court addressed that.
That's exactly right. So the district court latched on to the 2018 renewal that I mentioned in the overview of the facts, where ProMedica and St. Luke's extended the Paramount relationship in connection with the Cancer Center relationship. And so the district court said, oh, because you did this in 2018, it shows this was a profitable relationship, and now you're only terminating it to harm McLaren St. Luke's, and you're sacrificing profits. And the district court just misunderstood the facts and the changed circumstances. It overlooked the significance of McLaren acquiring St. Luke's. And that's what the Sixth Circuit shows. It says ProMedica in the 2018 renewal knew that it didn't want to do business with St. Luke's if it was acquired by another entity. That's why it made sure that the change of control provision existed. And that's a fact that district court overlooked. And that was why, in part, the Sixth Circuit reversed.
And how much of your argument rested on the notion that, or I should say, how would you have handled the case if it wasn't McLaren, if it was a smaller, less well-funded, less flexible, non-vertically integrated, perhaps, provider who was either entering into some sort of an affiliation that resulted in a change of control? I actually didn't go back to read the change of control provision, so I'm not sure what qualified as change of control in the agreement. But
no, that's a good question. It's something too that I was thinking about in preparation for oral argument, and I don't think the outcome changes, because that the change in control provision applied to any change in control. And just the existence of that provision suggested that the parties only viewed the relationship as profitable if St. Luke's remained St. Luke's. It didn't undergo any change in control. So the minute it underwent a change in control, that just changed the calculus of having the relationship. And from there, you can't impose a duty to deal because you're not engaging in conduct that doesn't make business sense. It's completely rational to terminate the contract because you negotiated for that provision.
I'd also say, I know not that your briefs weren't fantastic, but the amicus brief that was filed by the economists was pretty straightforward. It's much shorter than the parties' briefs. And if people are interested in sort of understanding the pro-competitive arguments for the termination, I found that really helpful, and actually a pretty quick read. So for folks who are interested in more on the sort of economic theory behind the pro-competitive arguments. Steve, I think you wanted us to cover also some of the government enforcement questions. Do you want
Yeah.
to? Okay.
I mean, basically, yeah. I mean, we know, if we've been following tech, that with the Biden administration, there's a new increased vigor and focus on antitrust enforcement, especially at the FTC. A lot of the focus has been on tech, but we've also seen that in healthcare, and a lot of the policy pronouncements have been targeted at healthcare. So, Barbara, I'll have you lead off the discussion on this. Do you see the government picking up in adopting this theory of harm, perhaps probably using different arguments and looking for different cases? But do you think this is something folks in the industry, either healthcare providers or managed care providers, should watch for increased government activity in whether it's the FTC, DOJ, or state AGs?
So I definitely wouldn't think that federal or state enforcement would be interested in this specific case. I mean, interested in becoming involved in, or because obviously the FTC was integrally involved in the consent decree, and I'm sure has been concerned and following the market generally, so the geography generally. So wouldn't think the specific case. I think the theory of harm. So I think refusal to deal is a really difficult argument for any plaintiff. And I have plenty of clients who raise the issue, and, we dig into it, we look at it, and it is a hard argument to make under the existing antitrust laws and the ways in which they've been applied, and the economic theories that we have relied on for the last many years in interpreting our antitrust laws. I do think that there is some suggestion or indication, hints from the agencies that they are more concerned about vertical mergers. So it is a real possibility that vertically integrated transactions will get closer looks, ones that involve a significant healthcare provider acquiring a substantial health insurance entity. I think that they will have concern with some of the potential harms that were alleged in the complaint, if in fact they continue down this road of sort of big is bad. I don't know that that causation necessarily goes from the allegations that were made. So the sort of alleged competitive harm that would have occurred for consumers, I don't know that that necessarily was caused by the actions of ProMedica. And so fundamentally, I think the theory is a difficult one. And I don't think that the agency are going to pick up on the theory in a context like this one. On the other hand, as I said, I do think they're very concerned about large healthcare providers, and they're concerned about consolidation, and they're concerned about the vertical elements of it. So I think situations like this, where a vertically integrated dominant provider acts, I think they will be interested in them. Whether, I don't see them running to bring a lot of enforcement actions, but I think if the right case came along and they felt that a provider was tipped to the point where they could no longer be competitively relevant, I think they might look at it. Here you've got McLaren backing up the plaintiff. It's kind of, I don't know that they would use enforcement, limited resources to pursue a case where there is a very well-funded plaintiff who can, work to improve their despite the loss of the volume from the Paramount relationship.
They're probably different facts. Maybe one thing you brought up too, probably maybe not in a pure refusal to deal case, but some of the similar issues, concerns about vertical integration and the health system with the integrated health plan.
Narrow networks, and also narrow networks. I think that it's possible that if somebody uses narrow networks as a weapon and they can't demonstrate the benefit that typically can flow from a narrow network. I have lots of clients. I mean, I represented OSF Healthcare System in the 7th Circuit in a case related to narrow networks. And, you can economically prove whether they benefit the consumers or not, and whether they harm competition. And so I think in cases where narrow networks don't demonstrably have benefit like that, that could be an area they would focus in when particularly if there's a vertically integrated defendant. They've highlighted non-competes, and they've highlighted concentration, and clearly, right, there are allegations here that, ProMedica controls the providers and doesn't allow providers to practice at St. Luke's who want to. So there are definitely pieces of the theory that I could see the agency having an interest in.
Yeah. I mean, I don't think there was a pattern allegation, but, Doug, and we're going off the agenda right now.
Okay.
But was part of the plaintiff's case that this was part of a pattern of anti-competitive conduct? And how did they, articulate that in the case, in their briefing or in arguments?
Yeah, it's a good question. Yes, yeah. So the plaintiffs primarily have a monopolization case where they're claiming that ProMedica is engaged in an overall scheme to significantly weaken McLaren, St. Luke's, or put them out of business. And one component of that is the refusal to deal on the insurance, but there's other conduct that both Barbara and you have pointed to, Steve, that's in the complaint. And the antitrust laws require a pretty rigorous analysis of that conduct. And I guess I like to use the phrase monopoly broth to describe incoherent theories of grab bag acts that are innocuous on their own, but you put them together into this broth to create a monopolization claim. And that's what the plaintiffs have done. That's what we told the Sixth Circuit. And antitrust law requires that you define a market, you show that there's specific acts within that market that harm competition in that market, and all these acts that you're referring to occur outside the relevant market. And the plaintiffs repeatedly pointed to acts outside the relevant market to try to prove their case, just to create confusion. And what we did in response is really be disciplined about how the right way to apply the antitrust laws is, which is define the market, look at the acts within the market, and see whether there's harm. And that's where the plaintiffs really failed here.
The district court was almost exclusively focused on the healthcare, the provision of healthcare market, and not on the insurance side at all. So looking at the share of Paramount, it was barely, it really was ignored in large part in the district court's decision, not in the appellate court decision, not in the Sixth Circuit. But yeah, I mean, it was very clear. The whole complaint really is focused on the dominance in the healthcare side and not at all on the insurance side.
That's interesting. Well, I mean, I guess now is a good time to end it off for a discussion on what the next steps, and also importantly, what are the takeaways for folks in this industry, either on the provider side or on the managed care side. And I'll turn it over to Barbara to lead that off, followed by Doug.
Sure. So obviously, right, we have a government, the White House, and the enforcement agencies who are very interested in the industry, as well as a lot of state regulators or enforcers. So I think my takeaways are not necessarily just related to this case, but these sorts of decisions, right, that providers and payers make. So one, I think it's always smart to be honest about the reasons for your decisions when those decisions might harm a competitor. And it seems like from the record and the decision and the opinions anyway, that ProMedica was pretty clear about why it was making this decision and didn't shy away from the fact that it had to do with the change in the nature of the competitor that was going to be entering the market. So I think honesty in why you're making decisions that can hurt a competitor is always a good practice. Mm-hmm. I think when you're narrowing a network or asking for a narrower network, regardless of whether you're on the payer side or you're on the provider side, the hoped for benefits from a narrower network should be clearly stated. It should be, even if it means preparing internal documents that lay out the reasons for the decision. Sometimes, if you can, I like to have my clients actually do the math of their decision. So, I mean, obviously, sometimes you can't do that, right? You're not going to go necessarily conduct an economic analysis of something. But if we're making a decision that could harm a competitor and it's a significant decision, I think not only documenting your reasons internally, but laying out the facts in support of your decision, and even, in a draft format, trying to do some of the math for that reason is really helpful when you're talking to courts that have lack of experience in the healthcare space in particular, but perhaps even lack of experience in business. I mean, there are lots of decision makers who've never actually worked directly with a business. That doesn't mean they're not competent to make the decisions, but this helps them to see why the decision was made and that it wasn't made with a thought or with any thought other than that we're going to be better at what we do. We're going to be able to help our payers and our patients. And I think when you're a vertically integrated health system or payer, you should really consider who's delivering the messages for you in the meetings when you're interacting with someone who, a potential plaintiff. And frankly, when I'm in these sorts of situations, some firewalls are useful. I don't mean necessarily official formal in all instances, but some sort of reflection that it really was an important decision that wasn't just driven by the idea of that a provider might want to harm its provider competitor in this context. So those are my takeaways. I'd be interested in hearing Doug's.
Yeah. And Doug, to the extent you feel comfortable, I know you're representing one of the parties, but to the extent you feel comfortable, if you could tell us specifically what are the next steps in this matter. I know recently a petition for rehearing was filed last week.
Yeah. Let me start with takeaways, and I'll get to the next steps on the matter. So my takeaways are that I think we'll see more monopolization cases, both from the government and from private plaintiffs. Refusal to deal claims will be hard. I have my fingers crossed that someday Aspen skiing will get reversed, but I don't think that's likely. But monopolization cases are here to stay, and healthcare providers, in particular, typically operate in consolidated markets with few competitors by the nature of the business. You need to be on the lookout for those types of claims when making business decisions. And so I think from a takeaway perspective, it would be smart when you're engaging in any conduct that disadvantages a rival to think about the implications of that conduct, talk to your in-house counsel, maybe talk to outside antitrust counsel, just to make sure you understand the full landscape of risks. And if you're on the other side of the coin where you've been disadvantaged by a potentially dominant player, you also might want to seek what options you have by talking with in-house counsel and outside counsel to make sure that you're exploring all the available options that you have. And so just on the next steps of the case, so the plaintiffs filed a petition for rehearing, and just the chance of success on a petition for rehearing statistically falls between less than 3% of the cases. And I'll just point out that the decision was unanimous and contained and was by the Chief Judge Sutton, and also joining in the decision was former Chief Judge Cole. So we'll see what happens with the petition for rehearing, but just based on the statistics, seems unlikely. And then the case, there's a larger monopolization case pending in the district court, and we'll need to work through those issues in light of the Sixth Circuit decision. But I can tell you that we've said this publicly, the case is meritless, and we've filed counterclaims, and we and fully expect to prevail on all the claims.
Okay. Yeah, and we understand. Yeah, that's your position too. Folks from St. Luke's, welcome to contact us, and we can schedule something to give your side too as well. Well,
I tried.
yeah. But thanks. This was great. This was informative. I found this to be very helpful as a healthcare antitrust practitioner. And if you guys, and for all the listeners out there, if you enjoyed this, I would recommend checking out the American Health Law Association, and specifically the Antitrust Practice Group. We have a lot of informative programs like that, whether they're brief, quick, informal podcasts such as this, or more formal webinars, and hopefully, once we get after this pandemic, more in-person conferences and brown bags, as well as written publications, bulletins, and alerts, which we try to put out frequently, which I think are very helpful for folks, whether you're a general antitrust practitioner, healthcare, as these folks, as Doug and Barbara can tell you, healthcare antitrust. Yeah, antitrust is antitrust, but due to the specific economics and the way at least healthcare distribution is set up in our country, there's certain specific issues that you have to deal with when you're advising folks on either side of the V, of the V potentially, in the healthcare industry where it comes to antitrust that you need to be aware of. And if you practice in the other area of healthcare, or you're a healthcare generalist, I guarantee you'll run into an antitrust issue one of these days for one of your clients. But thanks a lot. Thanks, Doug. Thanks, Barbara. This is very informative. And thank you all for joining us.